Good morning. Looking at 401 U.S. 371 in 1971, so of course it's after 1935, so it's applicable. Bodie et al. Versus Connecticut et al. Number 27. Supreme Court of the United States argued December 8th, 1969, November 17th, 1970, decided March 2nd, 1971, and it pertains to due process of law. And Mr. Anonymous got a hold of me and he said, "Hey, you want to help people out? You want to help them understand due process of law?" Bodie versus Connecticut is one of the most brilliant cases where essentially a thesis was created by a judge on due process of law. He goes, it's one of the most basic, fundamental pieces of knowledge that everybody should have in order to handle their own affairs, is comprehending due process of law and what it is. And he said, to date, this is one of the best thesis he's ever seen come out of a court pertaining to due process of law. And there was another thing that Bodie versus Connecticut showed us, is that the courts are open to us 24 hours a day, 7 days a week, and at no cost, okay? Because there is no money, so how do you pay, right? Appeal from the United States District Court for the District of Connecticut, author B. LaFrance regard the cause and filed brief for appellants. Raymond J. Cannon, Assistant Attorney General of Connecticut, the cause for appellees with him on the brief were Robert K. Killens, Attorney General, and William S. Kaplan. Alan Oshman filed a brief for the National Legal Aid and Defender Association as amicus curiae, urging reversal. Brief of amicus curiae urging affirmance were filed by Francis B. Birch, Attorney General of Maryland, and J. Mitchell McWilliams, Assistant Attorney General, joined by George F. Kugler, Jr., Attorney General of New Jersey, and Stephen Skillman, Assistant Attorney General, and by the following Attorney Generals: David P. Buxton of Delaware, Jack P. F. Grimillion of Louisiana, Clarence A. H. Meyer of Nebraska, Harvey Dickinson of Nevada, and Helgi Johansson of North Dakota, and Lee Johnson of Oregon. Mr. Justice Harlan delivered the opinion of the court. All right, here we go. Appellants, welfare recipient residing in the state of Connecticut, brought this action in the Federal District Court for the District of Connecticut on behalf of themselves and others similar situated, challenging as applied to them certain state procedures for the commencement of litigation, including requirements of payment of court fees and costs for services of process that restrict their access to the courts in their effort to bring an action for divorce. It appears from the brief and oral argument that the average cost to a litigant for bringing an action for divorce is $60. Section 52-259 of the Connecticut General Statutes provides, there shall be paid to the clerks of the Supreme Court or the Superior Court for entertaining each civil cause $45. An additional $15 is usually required for the service of process by the sheriff, although as much as $40 to $50 may be necessary where notice may be accomplished by publication. There is no dispute as to the inability of the named appellant in the present case to pay either the court fees required by statute or the cost incurred for the service of process. The affidavit in the record established that the appellant's welfare income in each instance barely suffice to meet the cost of the daily essentials of life and includes no allotment that could be budgeted for the expenses to gain access to the courts in order to obtain a divorce. So, necessity trumping law, necessity waives all fees to ensure that justice can be had, because justice does not come at a price, ladies and gentlemen. Justice it has nothing to do with the fiat world. Also, undisputed is appellant's good faith. Notice that? What am I always telling you guys and teaching you guys? Equity, all right? Clean hands, good faith, good conscience, for good reason. We do things because the law is written on our hearts. In seeking a divorce, assuming as we must on this motion to dismiss the complaint, the truth of the undisputed allegations made by the appellants, it appears that they were unsuccessful in their attempt to bring their divorce action into the Connecticut courts simply by reason of their indigency, or their failure to be able to pay, right? The clerk of the Superior Court returned their papers on the grounds that it could not accept them until an entry fee had been paid. APP 8 through 9, subsequent efforts to obtain a judicial waiver of the fee requirements and to have the court effect service of process were to no avail. Appellants thereafter commenced this action in the Federal District Court, seeking a judgment declaring that Connecticut statutes and service of process provisions requiring payment of court fees and expenses as a condition precedent to obtaining court relief are unconstitutional as applied to these indigent appellants and all other members of the class which they represent. As further relief, appellants requested the entry of an injunction, which is an equity. Equity is an injunction, relief, and in legal land and legalese, you have an estoppel. So we're looking at an injunction order, ordering the appropriate officials to permit them to proceed with their divorce action without payment of fees and cost. A three-judge court was convened pursuant to, which a three-judge court is a tribunal, ladies and gentlemen. A three-judge court was convened pursuant to Title 28 U.S.C. subsection 2281, and on July 16, 1968, the court concluded that a state may limit access to its civil courts, and particularly in this instance, to its divorce courts by the requirements of filing a fee or other fees which effectively bar persons on relief from commencing action therein. So that's a denial of due process of law, right? Everybody should have the ability to find remedy and justice in law, absent whether or not they're former paupers, they have the funds, they don't have the funds. Justice shouldn't look at that, right? We noted probable jurisdiction, 395 U.S. 974, 1969. The case was heard at the 1969 term and thereafter was set for re-argument at the present term, 399 U.S. 922, 1970. We now reverse. Our conclusion is that, Our conclusion is that, given the basic position of the marriage relationship in this society's hierarchy of values and the concomitant state monopolization of the means for legal dissolving this relationship, due process prohibits a state from denying solely because of inability to pay access to its courts to individuals who seek judicial dissolution of their marriage. At its core, the right to due process reflects and fundamental values in our American constitutional system. Our understanding of that value is the basis upon which we have resolved this case. Perhaps no characteristics of an organized and cohesive society is more fundamental than its erection and enforcement of a system of rules defining the various rights and duties of its members, enabling them to govern their affairs and definitively settle their differences in an orderly, predictable manner. Without such a legal system, social organization and cohesion are virtually impossible. With the ability to seek regularized resolution or conflict, individuals are capable of independent action that enables them to strive for achievement without the annexes that would best beset them in a disorganized society. Put more succinctly, It is this injection of the rule of law that allows society to reap the benefits of rejecting what political theorists call the state of nature. American society, of course, bottoms its systematic definition of individual rights and duties, as well as its machinery for dispute settlements, not on customs or the will of strategically placed individuals, but on the common law model. It is to courts or other quasi-judicial official bodies that we ultimately look for the implementation of a recognized orderly process of dispute settlement. Within this framework, those who wrote our original Constitution and the Fifth Amendment, and later those who drafted the 14th Amendment, recognized the centrality of the concept of due process in the operation of this system. Without this guarantee that one may not be deprived of his right, neither liberty nor property without due process of law, the state's monopoly over techniques for binding conflict resolution could hardly be said to be acceptable under our scheme of things. And here again, you got a judge using the word scheme of things. Only by providing that the social enforcement mechanism must function strictly within these bounds can we hope to maintain an ordered society that is also just. It is upon this premise that this court has thought years of adjudication put flesh upon the due process principle. Such litigation has, however, typically involved rights of defendants, not as here persons seeking access to judicial process in the first instance. This is because our society has been so structured that resort to the courts is not usually the only available legitimate means of resolving private disputes. Indeed, private structuring of individual relationships and repair of their breach largely encouraged in American life, subject only the caveat that the formal judicial process is, if restored to, is paramount. Thus, this court has seldom been asked to view access to the courts as an element of due process. The legitimacy of the state monopolies over techniques of final dispute settlements, even where some are denied access to its use, stands unimpaired where recognized. Effective alternatives for the adjustment of differences remain, but the successful invocation of this governmental power by plaintiffs has often created serious problems for defendants' rights, for at that point the judicial proceeding becomes the only effective means of resolving the dispute at hand, and denial of the defendant's full access to the process raising grave problems for its legitimacy. Recognition of this theoretical framework illuminates the precise issue presented in this case. As this court on more than one occasion has recognized, marriage involves interest of basic importance in our society. See Arago Loving versus Virginia, 388 U.S. 1, 1967, Skinner versus Oklahoma, 316 U.S. 535, 1942, and Meyer versus Nebraska, 262 U.S. 390, 1923. It is not surprising, then, that the states have seen fit to oversee many aspects of that institution. Without a prior judicial imprimatur, individuals may freely enter into and rescind commercial contracts, for example, but we are unaware of any jurisdiction where private citizens may covenant for or dissolve marriage without state approval, even where all substantive requirements are concededly met. We know of no instance where two consenting adults may divorce and mutually liberate themselves from the constraints of legal obligations that go with marriage. Legal obligations that go with marriage, telling you that there are more than two parties to a marriage, ladies and gentlemen. There are three parties, and the state is obviously involved, and they're telling you that right here. And more fundamentally, the prohibition against remarriage without invoking the state's judicial machinery. Thus, although they assert here due process rights as would be plaintiffs, we think appellants' plight because resort to the state courts is the only avenue to dissolution of their marriage, is akin to that of defendants faced with exclusion from the only former effectively empowered to settle their disputes. Resort to the judicial process by these plaintiffs is no more voluntary in a realistic sense than that of the defendant called upon to defend his interest in court. For both groups, this process is not only the paramount dispute settlement technique, but in fact, the only available one. In this posture, we think that this appeal is properly resolved in light of principle enunciated in other due process decisions that delimit rights of defendants compelled to litigate their differences in the judicial forum. These due process decisions, representing over 100 years of effort by this court to give concrete embodiment to this concept, provide, we think, complete, vindicate for appellants' contentions. In particular, precedent has firmly embedded in our due process jurisprudence two important principles upon whose applications we rest our decision in the case before us. Prior cases establish, first, that due process requires, at a minimum, the absent a contravailing state interest of overriding significance, persons forced to settle their claim of right and duty through the judicial process must be given a meaningful opportunity to be heard. Early in our jurisprudence, this court voiced the doctrine that wherever one is assailed in his person or his property, there he may defend. Windsor versus McVeigh, 93 U.S. 274, 277, 1876. See Baldwin versus Hale, 1 Wall, 223, 1864. Hovey versus Elliott, 167 U.S. 409, 1897. The theme that due process of law signifies a right to be heard in one's defense, Hovey versus Elliott, Supra at 417, has continually reoccurred in the years since Baldwin versus Windsor and Hovey, although many controversies have raged about the cryptic and abstract words of due process clause, as Mr. Justice Jackson wrote for the court in Mullen versus Central Hoven, tr.co, 339 U.S. 306, 1950. There can be no doubt that at a minimum, they require that deprivation of life, liberty, or property by adjudication be preceded by notice and opportunity for hearing appropriate to the nature of the case. What do we got when we do private administrative processes, ladies and gentlemen? We have a general correspondence, an initial correspondence. Hey, you kicked my dog. Here's the video evidence of you kicking my dog. It caused my dog injury. You harmed my property. I was caused harm, loss of time by taking my dog to the vet. Here's all the evidence. Here's all the bill. This is a first correspondence to be polite with you and give you an opportunity to remedy the situation. I'll give you 10 days to respond, and in 10 days, if you don't respond, I'm going to move forward with another action that may lead to court. Okay, so we're giving them notice and opportunity. The second one is going to be our notice and opportunity with the intent to sue Neely Deceit, which means he says nothing. And if they fail to respond to that, Neely Deceit's pretty much a open and closed principle, well established anyway. which I just learned about this the other day from a guy who's going to college at Yale to be a judge. And it was interesting, our conversation. He was a pretty brilliant man and spoke layman's terms just to break it down easy for me. Due process does not, of course, require that the defendant in every civil case actually have a hearing on the merits. A state can, for example, enter a default judgment against a defendant who, after adequate notice, fails to make a timely appearance. See Windsor Supra at 278, or who, without justifiable excuse, violates a procedural rule requiring the production of evidence necessary for orderly adjudication. Hammond Parking Co. versus Arkansas, 212 U.S. 322, 351, 1909. What the Constitution does require is an opportunity, right? Notice and opportunity, due process of law, granted at the meaningful time and in a meaningful manner. Now remember, when we look at equity, we realize that equity does not aid a volunteer, and equity does not aid somebody who is not vigilant about their rights. So if you're not doing your notice and opportunity right away, and you allow it to lapse for 6 months, a year, 2 years, whatever, before you decide you're going to come back, remember, you can't rub a dog's nose in a urine stain a week later. It doesn't do any good, ladies and gentlemen. And too much time has elapsed. There may be things that have been left out. There may be things that have been forgotten. So it's important to move swiftly, timely, and effectively in order to find your remedy, okay? Because equity does not aid the people who slumber upon their rights. Okay, so this is also a part of due process of law, and why I'm so adamant and vehement about learning equity, because equity is gorgeous. It's absolutely beautiful, and it'll help the layman, the common man, ascend to the mind and comprehend the basic fundamental principles, okay, which we've all been raised equitably for the most part. We just never knew what it was called. Armstrong versus Manzo, 380 U.S. 545 and 552, 1965. Emphasis added. For a hearing appropriate to the nature of the case, Mullen versus Central Hoven, TR Co. Supra at 313, the formality and procedural requisites for the hearing can vary depending upon the importance of the interest involved and the nature of the subsequent proceeding. That hearing required by due process is subject to waiver and is not fixed in form, does not affect its root requirement that an individual be given an opportunity for a hearing before he is deprived of any significant property interest, except for extraordinary situations where some valid governmental interest is at stake that justifies postponing the hearing until after the event. In short, within the limits of practicability, ID at 318, a state must afford to all individuals a meaningful opportunity to be heard if it is to fulfill the promise of the Due Process Clause. Our case further establishes that a statute or a rule may be held constitutionally invalid as applied when it operates to deprive an individual of a protected right, although its general validity as a measure enacted in the legitimate exercise of state powers is beyond question. Thus, in cases involving religious freedom, free speech, or assembly, this court has often held that a valid statute was unconstitutionally applied in particular circumstances because it interfered with an individual's exercise of those unalienable rights. No less than these rights, the right to a meaningful opportunity to be heard within the limits of practicality must be protected against denial by particular laws that operate to jeopardize it for particular individuals. See Mullen versus Central Hoven, TR Co. Supra, and Convey versus Town of Samores, 351 U.S. 141, 1956. In Mullen, this court held that the statutory provisions for notice by publication in a local newspaper, although sufficient as to the beneficiaries of a trust whose interests or addresses were unknown to the trustee, was not sufficient notice under the Due Process Clause for known beneficiaries. Similarly, Convey held that notice by publication in a foreclosure action, even though sufficient to provide a normal person with an opportunity for a hearing, was not sufficient where the defendant was a known incompetent. The courts expressly rejected an argument that the 14th Amendment does not require the state to take measures in giving notice to an incompetent beyond those deemed sufficient in the case of the ordinary taxpayer. Just as a generally valid notice procedure may fail to satisfy due process because of the circumstances of the defendant, so to a cost requirement valid on its face may offend due process because it operates to foreclose a particular party's opportunity to be heard. The state's obligation under the 14th Amendment are not simply generalized ones. Rather, the state owes to each individual that process which, in light of the values of free society, can be characterized as due. Number 3, drawing upon the principles established by the cases just canvassed, we conclude that the state's refusal to admit these appellants to its court, the sole means in Connecticut for obtaining a divorce, must be regarded as the equivalent of denying them an opportunity to be heard upon their claimed right to a dissolution of their marriage, and in the absence of a sufficient contravailing justification for state action, a denial of due process. The argument for this kind of fee and cost requirement are that the state's interest in the prevention of frivolous litigations is substantial. Its use of court fees and process costs to allocate scarce resources is rational, and its balance between the defendant's rights to notice and the plaintiff's rights to access is reasonable. In our opinion, none of these considerations is sufficient to override the interest of these plaintiffs' appellants in having access to the only avenue open for dissolving their allegedly untenable marriages. Not only is there no necessary connection between the litigant's assets and the seriousness of his motives in bringing suit, but it is here beyond present dispute that appellants bring these actions in good faith. Moreover, other alternatives exist to fees and cost requirements as a means for conserving the time of courts and protecting parties from frivolous litigation, such as penalties for false pleadings or affidavits, which is exactly what your district attorneys are doing when there's no affiance or man or woman bringing a claim. They're falsifying a record, putting it on the record, and it's a fraud upon the court. And everybody says, well, Derek, if you make that claim, you got to prove it. It's pretty self-evident what's going on. Ladies and gentlemen, when I ask to face the accuser and I do a conditional acceptance saying I'll pay any and all fees, any and all fines, provided I have the right to face my accuser and he can sit on the bench and provide testimony with firsthand knowledge of the things that I did or didn't do. Not talking about your witnesses. Give a shit less about your witnesses. I'm talking about a conditional acceptance that says that if you can bring the alleged man or woman making the claim, I'll provide remedy. Conditional acceptance, remaining in honor. Okay? So, and actions for malicious prosecution or abuse of process, to mention only a few. In the same vein, we think that reliable alternatives exist to service of process by state-paid sheriff if the state is unwilling to assume the cost of official service. This is perforce true of service by publication, which is the method of notice least calculated to bring to a potential defendant's attention the pendency of judicial proceedings. See Mullen versus Central Hanover TR Co. Supra. We think in this case, service at defendant's last known address by mail and posted notice is equally effective as publication in a newspaper. We are thus left to evaluate the state's asserted interest in its fees and cost requirements as a mechanism of resource allocation or cost recoupment. Such a justification was offered and rejected in Griffin versus Illinois, 351 U.S. 12, 1956. In blocked access to the judicial process, while in Griffin the transcript could be valid as a convenient but not necessary predicate to the court access, here the state invariably imposes the cost as a measure of allocating its judicial resources. Surely then the rationale of Griffin covers this case. In concluding that due process clause of the 14th Amendment requires that these appellants be afforded an opportunity to go into court to obtain a divorce, we wish to re-emphasize that we go no further than necessary to dispose of the case before us, a case where the bona fide or both appellants' indigency and desire to divorce, and here beyond dispute, we do not decide that access for all individuals to the court is a right that is, in all circumstances, guaranteed by the due process clause of the 14th Amendment, so that its exercise may not be placed beyond the reach of any individual. For as we have already noted, in the case before us, this right is the exclusive precondition to the adjustment of a fundamental human relationship. The requirement that these appellants resort to the judicial process is entirely a state-created matter. Thus, we hold only that state may not, consistent with the obligations imposed on it by the due process clause of the 14th Amendment, preempt the right to dissolve this legal relationship without affording all citizens access to the means it has prescribed for doing so. Reversed, Mr. Justice Douglas, concurring in the result, I believe this case should be decided upon the principles developed in the line of case marked by Griffin versus Illinois, 351 U.S. 12. There was considered a state law which denied persons convicted of a crime full appellate review if they were unable to pay for a transcript of the trial. Mr. Justice Black's opinion announcing the judgment of the court stated, such a denial is a misfit in a country dedicated to affording equal justice to all and special privileges to none in the administration of its criminal law. There can be no equal justice where the kind of a trial a man gets depends on the amount of money he has. Destitute defendants must be afforded as adequate appellate review as defendants who have money enough to buy transcripts. ID at 19. Griffin has had a sturdy growth. Our decisions for more than a decade now have made clear that differences in cases to the instruments needed to vindicate legal rights when based upon the financial situation of the defendant are repugnant to the Constitution. Robert versus Lavielle, 389 U.S. 40 and 42. See also Williams versus Oklahoma City, 395 U.S. 458. Long versus District Court of Iowa, 385 U.S. 192. Draper versus Washington, 372 U.S. 487. But Griffin has not been limited to securing a record for indigents who appeal their conviction. If the more affluent have counsel on appeal, then counsel for indigents must be provided on appeal of a criminal conviction. Douglas versus California, 372 U.S. 353. The tie to Griffin was explicit. In either case, Griffin or Douglas, the evil is the same. Discrimination against the indigent at ID at 355. In Burns versus Ohio, 360 U.S. 252, we invalidated a procedure whereby cases within the jurisdiction of the state Supreme Court would not be considered if a person could not pay the filing fee. In Smith versus Bennett, 365 U.S. 708, we held that the required indigents to pay filing fees before a writ of habeas corpus could be considered in state courts was invalid under the Equal Protection Clause. Here, Connecticut has provided requirements for married couples to obtain divorce, and because of filing fees and service of process, one of the requirements is having necessary money for more affluent can obtain a divorce. The indigent cannot. The situation is comparable to Burns versus Ohio and Smith versus Bennett. The due process clause on which the court relies has proven very elastic in the hands of judges. The doctrine that prevailed in Lochner versus New York, 198 U.S. 45, Copage versus Kansas, 236 U.S. 1, Adkins versus Children's Hospital, 261 U.S. 525, and J. Burns Bacon Co. versus Bryan, 264 U.S. 504. And like cases, the due process authorizes courts to hold laws unconstitutional when they believe the legislator has acted unwisely, has long since been discarded. Ferguson versus Skrupa, 372 U.S. 726 730. I would not invite its revival. Whatever residual element of substantive law the due process clause may still have, Thompson versus Louisville, 362 U.S. 199, it essentially regulates procedure. Snadicha versus Family Finance Corp., 395 U.S. 337, Wisconsin versus Constanua, 400 U.S. 433. The court today puts flesh upon due process clause by concluding that marriage and its dissolution are important, that an unhappy couple who are indigent should have access to the divorce courts free of charge. Fishing may be equally important to some communities. May an indigent be excused if he does not obtain a license which requires payment of money that he does not have. Ladies and gentlemen, let me explain to you what was just said right here. This goes back to the right to forage for food, necessity trumping law. And because there is no money, it's only fiat in the system, and they're not allowing us, for whatever reason, to create our negotiable instruments, and they're not honoring them. The bank, being a third-party intervener, is supposed to be wheeling and dealing these negotiable instruments and taking them to the Treasury and having them offset and discharged as they're supposed to be. But listen to what this justice says. He says, may an indigent be excused if he does not obtain a license which requires payment of money that he does not have. Essentially telling you that you have the right to forage for food, and it's a basic fundamental right. And if somebody was to seek to infringe on that right, ladies and gentlemen, you could weigh heavily on the fact that necessity trumps law, and we all have an unalienable right to survive, which means hunt, fish, and make a living. Okay? How about a requirement of an erroneous bond to prevent summary eviction from rented property? The affluent can put up the bond, though the indigent may not be able to do so. See Williams versus Schaefer. Williams versus Schaefer, 385 U.S. 1037. Is housing less important to the Michelage Holding Society together than marriage? The example could not be multiplied. I do not see the length of the road we must follow if we accept my brother Harlan's invitation. The question historically has been whether the right claimed is of the very essence of a scheme of ordered liberty. Pollock versus Connecticut, 302 U.S. 319, 325. That makes the test highly subjective and dependent on the this is going to be a tough word. I'm going to do it. Idiosyncrasies, IDIOSYNCRASIES idiosyncrasies of individual judges, as Lochner, Copage, and Atkins illustrates. The research of the Equal Protection Clause is not definable with mathematical precision, but in spite of doubts by some, as it has been construed, rather definite guidelines have been developed. Race is one. And it goes into Strotter versus West Virginia, 101, U.S. 303. McLanglan versus Florida, 379, U.S. 184. Alienage is another. That's Takoski versus Fish and Game Commission, 334, U.S. 410. Religion is another. Sherbert versus Verne, 374, U.S. 398. Poverty is still another. Griffin versus Illinois, Supra, and class or caste, yet another. Skinner versus Oklahoma, 316, U.S. 535. The power of the state over marriage and divorce is, of course, complete except as limited by specific constitutional provisions. But could a state deny divorce domiciliaries who were Negroes and grant them to whites? Deny them to resident aliens and grant them to citizens. Deny them to Catholics and grant them to Protestants. Deny them to those convicted of larceny and grant those convicted of embezzlement. Here, the individuous discrimination is based on one of the guidelines, poverty. And individual discrimination based on poverty is adequate for this case. While Connecticut has provided a procedure for serving the bonds of marriage, a person can meet every requirement, save court fees and cost of service of process, and be denied a divorce. Connecticut says in its brief that this is justified because the state does not favor divorce and only permits a divorce to be granted when those conditions are found to exist. In respect to one or the other of the named parties, which seems to the legislator to make it probable that the interest of society will be better served and the parties will be happier, and so the better citizens separate than if compelled to remain together. Thus, under Connecticut law, divorce may be denied or granted solely on the basis of wealth, just as denying further judicial review in Burns versus Smith, appellate counsel in Douglas, and a transcript in Griffin created an individuous distinction based on wealth. So too does making the grant of denial of a divorce to turn on the wealth of the parties. Affluence does not pass muster under the Equal Protection Clause for determining who must remain married and who shall be allowed to separate. And I'll leave you with that. I've got to get going. I've got some more studying to do. I've got some calls to take. Where I'm leaving off at is Mr. Justice Brennan concurring in part. And this is found at scholar.google.com and at scholar_case !case =708 or 705 683 509 4703 49993, the and sign, Q, the equal sign, and that's where you can find this. And I'll actually show it to you real quick just so you can see it. And let's see. I probably have to reverse this camera to help you out. There you go. So you can see it, you can pause it, you can go find the case. And this is where we're leaving off. But this was a suggested read by Mr. Anonymous. He cares greatly about people and just wants them to start exercising their free will, becoming consciously aware and cognitive of what's truly transpiring. And this is due process of law. He said it's one of the best theses he's found on due processes of law and the miscarriage of justice based upon fines, fees, and other filings. Okay? Thanks for joining me.